Listen closely, because what you're about to hear could upend everything you thought you understood about citizenship, immigration, and your family's future in the United States. Right now, at this very second, countless families across America are waking up to a reality they never imagined they'd face. Mothers and fathers in hospital maternity wards, still holding their newborns, are suddenly being confronted with questions that would have sounded impossible just a short time ago. Immigration lawyers are getting urgent calls at levels they've never seen before. Families who believed their path to U.S. citizenship was straightforward are now lying awake at night, gripped by doubt and fear. This isn't rumor, this isn't hype, this is unfolding in real time. And if you, or anyone you care about, has any connection to the American immigration system, you need to understand what's happening. Welcome to U.S. Visa Updates, where we break through the confusion, unpack complex immigration shifts, and give you clear, practical information to help safeguard your family's future. Today, I'm going to walk you through one of the most dramatic turning points in U.S. immigration history, a change so sweeping that some legal experts are comparing it to earlier landmark moments that redefined who gets to call themselves American. Before we dig into the details of this critical issue, I'm going to ask you to do one simple thing that costs you nothing, but means everything for our mission to keep families informed. Hit the subscribe button right now. Tap the notification bell so you never miss an update that could affect your immigration journey. And if this video sheds light on something you or your community are going through, leave a comment below and tell us your story. Your engagement helps us reach more families who desperately need this information. Now, let's talk about what is really happening across the country. Picture this. You're a parent. You've lived in the United States for years. Maybe you're here on a valid work visa. Maybe you're a student at an American university. Maybe you run a business that employs U.S. workers. You've followed the law. You've filled out every form. You've paid every fee. Your baby is about to be born here, in an American hospital. And for as long as you can remember, for as long as your parents and grandparents can remember, you've believed something simple. If your child is born on U.S. soil, they are automatically a U.S. citizen. No questions, no extra steps, no uncertainty. That foundational belief, the promise that has stood for well over a century, has now been shaken at its core. What used to be automatic and universally understood has become conditional, complicated, and deeply uncertain. The principle at the heart of this shift is birthright citizenship. For more than 125 years, it worked on a clear, almost elegant rule. If you were born in the United States, you were an American. Full stop. It didn't matter if your parents were tourists, international students, temporary workers, or even people without legal status. The place of birth determined citizenship. This wasn't just a bureaucratic policy. It was part of America's identity, rooted in the Constitution and reinforced by generations of court decisions. Hospitals didn't have to investigate immigration status. Parents didn't have to bring in immigration files. A baby born here was American, and that was the end of the story. But that story has been dramatically rewritten. A sweeping executive directive has reinterpreted how citizenship at birth is determined, and the consequences are rippling through. Every hospital, every vital records office, every immigration help center, and every immigrant community in the country. Under this new framework, simply being born in the United States is no longer enough to guarantee automatic citizenship. Instead, what matters now is the legal status of the parents. Under the updated policy, a child born in the U.S. receives automatic citizenship only if at least one parent meets one of two conditions. They are already a U.S. citizen, or they are a lawful permanent resident, a green card holder. Think for a moment about what that means in real life. If both parents are here on temporary work visas, even if they've been living and working legally in the United States for many years. Their U.S.-born child may no longer receive automatic citizenship. If both parents are international students, pursuing degrees at American universities, and contributing to U.S. research and innovation, their newborn may be left in legal uncertainty. If both parents are asylum seekers waiting for a decision, visitors on tourist visas, or people currently without lawful status, their child, born inside a U.S. hospital, now enters a legal maze that simply did not exist before. This policy does not single out any one nationality, religion, or region. It applies across the board to everyone, regardless of where they are from or why they are here. The moment this directive was issued, federal agencies were instructed to immediately stop treating all U.S.-born children as automatic citizens, unless the new parental status criteria were met. Hospitals that had followed the same simple procedures for generations suddenly found themselves pulled into the middle of immigration enforcement. Doctors and nurses whose job is to care for mothers and newborns are now being asked to confirm immigration status, review documents, and confront legal questions they were never trained to answer. Birth certificates, which once symbolized pure joy and a fresh start, now come attached to questions about green cards, naturalization papers, and current status. State offices responsible for birth records and citizenship-related documentation have been forced to rapidly overhaul systems and processes that had been stable for decades. What used to be a routine clerical task now involves interviews, document review, and often follow-up investigations. What was once completed in minutes can now drag into days or weeks. What used to require basic information now demands extensive supporting evidence. What used to be certain now requires verification and sometimes legal representation. The bureaucratic weight of this change is enormous, but the human impact is even heavier. Parents who never imagined they had anything to worry about are suddenly filled with dread. They're asking questions. That would have sounded absurd not long ago. Will my baby be recognized as an American citizen? What documents do I need to bring with me when I give birth? How will this affect my child's ability to enroll in school, get a passport, or qualify for health coverage and other benefits? And in the most extreme and painful cases, could my child end up stateless, belonging to no country at all? The nationwide reaction was immediate and intense. Within days of the directive being announced, lawsuits began to flood into federal courts across the country. Civil rights organizations mobilized, arguing that a change this fundamental to citizenship law cannot be made by executive directive alone. Immigration advocates joined forces with constitutional scholars to challenge the legal and constitutional basis for the policy. Several state governments, alarmed by the chaos on the ground, filed their own legal challenges. Their argument was simple. If the nation is going to change something as central as who is an American citizen, it must be done through Congress, not unilateral executive action. For a brief period, it looked like the policy might be halted nationwide before it could truly take effect. Multiple federal district courts issued temporary restraining orders and preliminary injunctions, blocking implementation within their jurisdictions. The result was an incredibly confusing patchwork of rules. In some states, hospitals continued operating under the old framework, granting automatic U.S. citizenship to all children born on their soil. In others, the new verification procedures and parental status requirements kicked in immediately. Families in mixed-status households, where some members are citizens or green card holders and others are not, were thrown into limbo. A child born in one state could be recognized as a citizen, while a cousin born the same day in a neighboring state might encounter totally different rules. The inconsistency was infuriating. The uncertainty was crushing. Then came a development that changed the legal landscape. The U.S. Supreme Court stepped in, not to decide whether the new citizenship policy itself was constitutional, but to address a different, highly technical question. Do individual district courts have the authority to issue nationwide injunctions that block federal immigration policies everywhere? In a decision that stunned many legal observers, the court concluded that individual district courts do not have broad power to impose nationwide blocks on federal immigration directives. This might sound like a procedural detail, but its real-world consequences were enormous. Almost immediately, many of the temporary nationwide blocks were lifted. The directive became enforceable across much of the country, although a few states managed to maintain limited protections through ongoing state-level litigation and different legal arguments. In practical terms, that means the policy is now being implemented across most of the United States, even though the underlying constitutional questions are far from settled. Most experts expect these issues to continue working their way back up through the courts, possibly returning to the Supreme Court, for a definitive ruling on the substance of the policy itself. But while the legal battle drags on, families cannot simply press pause on their lives. They are living with this new reality, today, right now, in delivery rooms, immigration offices, and community clinics. And the impact varies dramatically, depending on where they live. In states where enforcement is temporarily on hold due to ongoing legal protections, families feel a fragile sense of relief, always overshadowed by the fear that the pause could be lifted at any time. In states where the directive is fully in force, the change is felt on a deeply personal level. Hospitals must verify the immigration status of at least one parent before issuing citizenship-related documentation for newborns. Parents are expected to produce green cards, citizenship certificates, visas with valid status, or other proof of lawful presence. Families who don't have those documents on hand because they're lost, stuck in processing, or simply don't exist, are plunged into confusion and fear. Community organizations that support immigrant families report an explosion of calls from anxious parents. These are not people trying to manipulate the system. These are mothers and fathers, desperately trying to understand what rules now apply, what documents they need, and how they can plan for their children's futures. Under a dramatically altered legal landscape, immigration lawyers, who were already overburdened, are now completely swamped. Nonprofit legal services are stretched to the breaking point. Advocacy groups are scrambling to run emergency workshops, town halls, and legal clinics just to give families a basic roadmap of what to expect and how to respond. And the ripple effects spread far beyond the moment of birth. School districts are struggling with enrollment and documentation questions for children whose citizenship status is uncertain. Healthcare providers are unsure how to handle eligibility for Medicaid, CHIP, or other public health programs. Parents are panicking about whether they can obtain passports for family travel or even basic IDs for their children. Every administrative complication represents a real family facing real consequences. And just as families are trying to wrap their heads around this shift in birthright citizenship, another major change has shaken the immigration system, this time affecting family-based immigration. We're talking about the process by which U.S. citizens and permanent residents petition to bring close relatives to the United States or help them adjust their status if they're already here. At the center of that process is Form I-130, the petition for alien relative. For decades, the I-130 has been the starting point for family reunification, allowing Americans to sponsor spouses, children, parents, and siblings. Traditionally, the core focus of the I-130 process was fairly straightforward. Is the claimed family relationship real and legally valid? Applicants had to show that their marriage wasn't a sham, that parent-child relationships were legitimate and documented, and that sibling relationships were properly proven. It could still be a demanding process, but attorneys and families understood what was required. The rules were relatively stable. Now, that process has evolved into something far more expansive and far more demanding. Applicants are reporting that the forms themselves have grown significantly in length, with new and expanded questions that reach deeper into areas that previously received only limited attention. Requests for supporting evidence have multiplied. Financial disclosures that once required basic income and employment information now demand detailed breakdowns of income sources, bank records and assets, debts and financial obligations, employment histories extending back many years. And, in some situations, information about the financial circumstances of extended family members, evidence of family relationships, once often satisfied with wedding photos, joint bank accounts, leases, and sworn statements, now must be much more extensive, cover longer periods of time, and document more aspects of the couple's or family's life together. Background checks, which have always been part of the process, have become noticeably more intensive. Officials are probing more deeply into past employment and residence history, international travel patterns, prior immigration violations, even minor or long-ago issues, criminal records, including offenses that might not normally be disqualifying, inconsistencies between past applications, interviews, and current statements. Across the board, the level of scrutiny has increased, and with it, processing times, which were already painfully long, are expected to stretch even further. Families who were once bracing for months or years of separation from loved ones now face the possibility of even longer waits. And this expanded scrutiny doesn't just apply to one type of petition. Whether you're sponsoring a spouse you've been married to for decades, a minor child, an elderly parent, or a brother or sister, you are now subject to the same heightened level of examination. Government officials describe these changes as necessary to safeguard the integrity of the immigration system, to fight fraud, and to ensure that new immigrants will be self-sufficient and not become public charges. But families and advocates worry that a system intended to prioritize family unity is becoming steadily more restrictive, more expensive, and in many cases, nearly impossible to navigate, especially for those who have limited financial resources, struggle to afford experienced legal representation, or come from countries where record-keeping is weak, inconsistent, or dangerous to access. When you put together the transformation in birthright citizenship with this tightening of family-based immigration, the picture becomes clear. This is more than just a few administrative tweaks. We're seeing a fundamental philosophical shift in how the United States approaches immigration. The direction is unmistakable. More regulation at every step, greater demands for documentary proof of nearly every claim, deeper and more skeptical review of every application detail. Whether this will ultimately bring the security and order that officials promise, or whether it will create new backlogs, new inequities, and new hardships for families, remains an open question. Only time will tell. As legal challenges work their way through the courts, as new policies are proposed, as political winds shift, and as families adjust to these new realities, one thing is beyond dispute. The United States is at a genuine crossroads. Historians will likely look back on this period as a pivotal moment in redefining immigration policy, citizenship law, and family unity. The full impact of these changes will not be visible tomorrow or next week. They will unfold gradually. In classrooms where children enroll, or are turned away, based on their status, in hospitals where babies are born under a cloud of legal uncertainty, in workplaces where immigrants contribute every day to the U.S. economy, and throughout the vast immigration system that touches millions of lives, for families currently navigating visa applications, preparing sponsorship petitions, or expecting the birth of a child, staying informed is not optional. It's essential. Knowledge is not just power in this environment. Knowledge is protection. Knowing the current rules, understanding what documents you need, Being aware of your rights and options, these things can be the difference between a successful outcome and a heartbreaking denial. These changes are not just shaping lives right now. They are redefining who will become American, how families can stay together, and what the United States will look like in the years and decades ahead. As new policy ideas surface, as political debates intensify, and as courts continue to issue decisions, one reality stands firm. The American immigration landscape is shifting rapidly and dramatically. Understanding the rules as they exist today, this moment, may be the key to protecting your family's future, preserving your path to citizenship, and avoiding becoming another casualty of a system in flux. That is why channels like U.S. Visa Updates exist. Our goal is to bring you clear, accurate, and timely information about every development that could touch your immigration journey. We're not here to tell you what to believe politically. We're here to explain what is happening legally, what it means in practice, and what steps you can take to protect yourself and your loved ones. If this video has revealed changes you didn't know about, answered questions you were afraid to ask, or helped you see the bigger picture of what's happening in U.S. immigration, take a moment right now. Like this video, share it with anyone who might be affected, and comment below, telling us what immigration topics you want us to break down next. Your engagement helps us reach more families, and together, we can build a community of informed, empowered immigrants who understand their rights and their choices. Subscribe to U.S. Visa Updates, turn on notifications, and stay informed. Because in this fast-changing environment, ignorance is not an option, and information may be your strongest protection. Where we break through the confusion, unpack complex immigration shifts, and give you clear, practical information to help safeguard your family's future. Today, I'm going to walk you through one of the most dramatic turning points in U.S. immigration history, a change so sweeping that some legal experts are comparing it to earlier landmark moments that redefined who gets to call themselves American. Before we dig into the details of this critical issue, I'm going to ask you to do one simple thing that costs you nothing but means everything for our mission to keep families informed. Hit the subscribe button right now. Tap the notification bell so you never miss an update that could affect your immigration journey. And if this video sheds light on something you or your community are going through, leave a comment below and tell us your story. Your engagement helps us reach more families who desperately need this information. Now,